understanding about the functioning of ARO in relation to the regulation we are speaking about. Let me start with my presentation that will last 10 minutes. We will share it. That explains the immediate hypothesis I have in my mind. It's about the relevance or much more importance of the regulation we are discussing. Also, if the regulation is not the only instrument for cooperating on seasonal confiscation. The title is that there are, it's a question, two opposite trends in Europe. Organized crime is going to be much more internationalized. We will see the data about. And on the other side, it seems, or it looks, there is a less trend in seizure confiscation data, at least for Italy. The presentation will conclude with a question mark. I will explain when we reach. Go ahead. These are the data coming from Europol, the recent report done in 2024 that explains the level of internalization of organized crime. It's quite clear what they say. They speak about 821 groups configured as organized crime groups in Europe, in all the member states, and the number of people belonging to these groups and the different activities. It's very important. You can download this report from Europol, from everywhere. And the typology is about what they do in terms of activities. You see fraud, polycriminality, or others. But it is more important what Europol says about the composition of these groups, because this gives the flavor of what I speak about internationalization of organized crime in Europe, which means that what they say, data in this case are coming from law enforcement agencies all over member states, which means that these are not perceptions, but these are data coming from law enforcement. Okay, we can open a question mark about the reliability of this data, but in some ways, these are the less worst of the best data available in Europe today about organized crime. Exception for the other data coming from perceptions, but we are not considering data coming from perceptions. So it's important, the data about 112 nationalities, part of the groups, the 821 groups, networks. And it's important to look at that 68% of these groups are composed by multiple nationalities, and this gives to you the idea of how international they are. On this side, the question is if there is a nexus between more internationalization of organized crime and the number of confiscation measures inside a single country. The hypothesis we have here, it's only an hypothesis, but we need to check for the other member states, that criminal organizations are moving abroad their assets, or they are investing abroad in order to reduce the amount of the law enforcement risk, which means conviction from one side and the risk also that the assets will be confiscated. That means, in a few words, criminals, because of internationals, are moving where the risk is less. What Matteo Anastasio will present as the next presentation are data about numbers which have been provided by the European Commission, the Minister of Justice, the AROs, that show how low are the data about the implementation of the regulation, which is quite important because this is the main instrument for judicial cooperation. Well, let me look if it is true there is a trend in Italy about the reduction of confiscation measures and seizures, look to this data about Italy that Matteo has collected, where you have a peak in 2015 and the reduction coming until today. These are the numbers, the measures independently from what are the different assets, if buildings or industries or others. Confronting this trend with the previous one, data about internationalization, the answer is a big doubt. At least for Italy, it could be that criminals have anticipated the reduction of effectiveness of the instruments we have for confiscating a seizure abroad. When we will look to the presentation of Matteo about the data, we can have an answer about this kind of things. And I conclude here explaining what is the question mark. What about the other member states? Are we assisting into the same reduction or not? This will follow in the next few months. But it will be important to see if the trend is the same as in Italy, at least for Italy. Thanks a lot. Okay, Matteo now.
Thanks, Professor. Just some brief logistical organizational things. The first one is that we are recording this event, and by participating, and we will publish it in the website, in our website. So by participating, you agree into the registration and publication into our website. And besides, since there could be some external participants, not partners, we are sharing the EU survey that you should complete by the end of the meeting that aims to assess that aims to assess the quality of the meeting. You find in the slide all the details about what should you do, and we are adding to the chat also this information. Having said that, thank you very much for being here, and we proceed with the second presentation by me and Laura on the data that the professor was mentioning. So let me share it. Okay, you should see it. So yeah, this presentation will revolve around some data that we are currently collecting within the framework of this project, and they come from the European Commission that's given us the data that member states are annually communicating to the European Commission on the implementation of regulation, and they will come also from Colonel Ribaudo, who really kindly provided us with some useful information about the Italian ARO and the requests that it receives. So first point, this is a figure showing the seizure and confiscation under the regulation received by all the member states in 2021 and 2022, according to the data of the European Commission. So yeah, I'm sorry, because, okay. Here you can see that in blue, there's the detail about the freezing orders, and in a lighter color, there is the detail about the confiscation orders. Generally, freezing orders are much higher than confiscation orders. In darker blue, you see where the distinction between freezing and confiscation orders was not available by the data. In general, you see that the numbers are high, I would say, for Netherlands and Bulgaria, maybe Lithuania, but in general, very low for the main for the main European countries, to Germany, Italy, France, and all. So to go on, to proceed. This is the figure showing the orders, seizure and confiscation orders received by Italy in 2021 and 2022. As you can see, again, the same mechanism. So this is the sending state, and we have Germany and France. So geographical proximity, let's say, and also the fact that they are big countries. But in general, we are counting like 12 requests from Germany, of which 9 of freezing and 3 of confiscation. and 11 freezing requests by France. So the numbers again are quite low also regarding all the other states. We then have also the predicate offenses of these requests. And as you can see, the regulation should, or at least it should contribute to the fight against organized crime. But what we see is that as regards Italy, organized crime is the third predicate offense with 3 requests, of which 1 freezing order and 2 confiscation orders in 2021 and 2022. So this is a very low threshold, and it's a very low amount. And in general, what we see is that the highest part of these orders are for fraud. So as you can see, 35 orders here are just for fraud. And so the way the regulation is currently applied, at least in Italy, but probably in many other member states, is for, I would not say petty criminality. Of course, fraud is not petty, but it is not the most serious forms of organized crime that we currently face in Europe. Then we have the seizure and confiscations that Italy has sent to other member states in 2021 and 2022. Again, there is a geographical proximity, at least for the first 2, but in general, we don't have the details here for what order is a freezing one and what orders is a confiscation one, but the numbers are quite low. The maximum is Spain with 16 orders sent, which is quite low for the 2 years span that we are considering. And these are all the other states. Then this is the same slide that the professor was showing. Our question is, we see here in Italy from 2015 on a decrease into the freezing confiscation orders by the authorities. What we would like also to understand with your contribution in the following month is if this is true also in other member states. We know that member states have many ways to confiscate and seize and to tackle organized crime, but it could be interesting to understand if this is a shared trend, if this is not, and if this is, and if it is a common trend, why it is so. In general, as I was saying, you can see that there's a quite a significant decline from 2015 on the goods that the Italian authority manages and on the goods that are subjected to seizure and confiscations. Going on, this is just a detail on the assets that the agency for the management, the Italian agency for the management of assets manages currently. Is just to say and to show that real estate has the highest rank here in all the years, basically. This is not true. We will see that for the goods that Italy confiscates and seizes abroad. But this is just to show that usually in Italy you confiscate real estates and to a lesser extent other goods such as movable goods. Registered movable goods means mainly car and ships in general. So we now go to the core of the workshop, the 2 days workshop, meaning ARO structures and activities, and also the data by the Italian ARO. In general, again, these data were provided us kindly by Colonel Ribaudo, and we had a file with the information about all the AROs in Europe, and we extracted some general statistical information, meaning that, for example, one of the core points of this workshop, we would like to stress the importance of the nature of the ARO. So the judicial AROs, the police AROs, and the multidisciplinary AROs. According to the data we have, the majority of European AROs are police AROs. Then we have a slighter amount of multidisciplinary ARO and an amount of judicial ARO. Then this is the average staff per ARO category. As you can see, the multidisciplinary has generally the highest number of staff, followed by the judicial and the police that relies on a tiny force, I would say, in general. Then we have if AROs are central point for incoming mutual legal assistance requests related to asset recovery, this is the yes, is this color, is this green, and the judicial AROs are usually more than the other categories, of course, central point for mutual legal assistance requests. But as you can see, the judicial AROs in Europe are 6 in total compared to 8 multidisciplinary and 18 to police. So it is true that judicial AROs in general are the first point for the mutual legal assistance requests, but this is not true in all the EU member states. This is a figure showing the percentage of AROs that collect relevant statistics on freeze and confiscation orders. As you can see, again, judicial AROs, is the yes, is this green, collects like 70%, 65% of judicial AROs collect data about freeze and confiscation orders. This percentage is quite lower in the other categories. And in general, for multidisciplinary AROs and police, there is a percentage of collection statistical data that is below 50%, which is quite low, and we should definitely improve this aspect. Then we have the data on the requests for assistance to the Italian ARO, that the Colonel Ribaudo may better specify the content of the requests and all the work they are doing in this regard. In general, the bar chart shows the authority from which the requests is coming. The requests come. So we have the highest column is AROs asset recovery, which means AROs abroad, which are the highest value of requests sent to the Italian ARO. And we have then national authorities, which are in the other colors, which are much lower in terms of requests. So we could say that at least the request of assistance that the Italian ARO receives are significant, are about 700 to 900, which is quite a good amount. Then the thing is, the problem is to understand how many of those requests actually go into a regulation and how much all those requests contribute to the mutual recognition and to asset recovery in Europe. In general, the trend in 2024, of course, is declining, but this is just because data are until April this year. For the rest, you can see that the trend is quite going higher. So requests are significantly increasing. This is the general trend of all the requests coming from abroad and from Italy, the line. So this is the graph showing the countries of origin of foreign requests for the Italian ARO. We have France. These are all the years that are declining in shades by the years. So we have France, Romania, Netherlands, Spain, and we have all the details about the requests coming from abroad. This is just the requests coming from foreign AROs, and you can see that they are augmenting a little bit in the first states. They are quite the same, or in general in the other states, or maybe they're just increasing a little bit. So there is a general trend of increasing, as we have seen in terms of requests received by the Italian ARO. Then we have the assets frozen by Italy abroad. As I was saying, Colonel Ribaudo also gave us some data about the assets frozen and confiscated abroad by Italy. And here you can see the frozen ones. The same mechanism. The bar chart shows the type of the good, and the line shows the total value of all the goods. This is the value of the goods. And so we have movables. As I was saying, in Italy, we confiscate more non-movable goods, real estate in general. That is probably one of the most important assets for criminal organization and for mafia type criminal groups. In general, abroad, Italy confiscates more movable goods, which is also a point, meaning what kind of criminality are we tackling abroad, since also there is this difference. So this is all the facts and figures related to the value of the goods and the general value. We have the assets here confiscated abroad, but I'm sorry, yeah. This is the asset confiscated abroad. Let's start from here. As you can see, the total value is like lower compared to frozen assets, so confiscation is not quite used. And also here we see a slight decline in 2023. I think data should be complete here. So this is the same figure related but to confiscated assets. And here we have the countries to which Italy confiscates assets. And we have Malta and Switzerland and the Netherlands in general. As you can see, the number is quite low. Again, we are talking about 5, 6 confiscated assets abroad in several in the span of 4 years. As a general remark, the final slide I've shown you also include other countries, not only the EU1, such as the United Kingdom, but also United States, there should be. So in general, this is a general overview, not telling us how the regulation is applied, but just giving us some insights about confiscation and freezing abroad as regards Italy. So that should be all. And thank you very much for your attention. And if you have any question, of course, we're perfectly available.
Good.
Yeah.
I think the next speaker is Colonel Ribaldo. We have been speaking about its contribution to data. Many of the data that Matteo has presented are coming from Colonel Ribaldo, who is leading the ARO office in Italy, police cooperation particularly. Colonel Ribaldo has been so kind to explain us the different procedures and the different structures that are dealing with the ARO systems in Italy, and this was a precious contribution, and I really thank him for explaining also the other country. He gave us the data about the structure of the ARO in all the member states, explaining the different composition, and this is going to be my comment, how difficult it could be the cooperation between judicial and police, because they go through different itineraries that explains in some ways also what changes should be done in the systems. But Colonel Ribaldo, the word is yours.
Thank you so much. A warm welcome to all the participants, and thank you to the organizers for giving me the opportunity of sharing a couple of opinions about the ARO network. Well, the title of my intervention is quite cross-cutting, so I will touch a lot of topics. I don't want to anticipate, for example, that there have been some improvements in the EU regulations and laws on the specific topic of asset recovery. Professor Mogeri will talk about later about the newly entered into force EU Directive 1216, which I and other ARO colleagues have strongly contributed in writing down with the DG Home, because we seized the opportunity to make a treasure, so to say, of the experience made in the time span between 2007, when the Council Decision 845 established for the first time a formal asset recovery office network throughout the European Union, and 2022, when there was the first draft of the EU directive, which has been approved by the Council and the EU Parliament very recently. And it entered into force in May 2024. Well, talking about, for example, the issue of tracing and recovering assets. First of all, talking about investigators, a concept which encompasses both the police forces and the judiciary. It's an issue that comes, let's say, at the very end of the investigative process, because First of all, you have, if you are tackling organized crime with the old-fashioned but still efficient systems like wiretapping and other investigative system, then you add financial investigations to trace the money and to see where economical and financial movements are used to cover, to launder the illicit money gained by the illicit traffics of the organized crime. Well, then you have to summarize all the work you have done, and you have to trace the goods and the assets you have to seize per equivalent, for different ways the legal framework gives to the different law enforcement agencies the possibility to catch up all the assets related to the organized crime and provide sufficient, strong, robust elements or evidence, if needed by the different legislations, to prove to the court or to a judge that those goods are freezable, seizable, or confiscable. So again, being the investigation an art and not a cold procedure to be followed according to a handbook, you also have to find the right moment where to begin to trace and to recover the assets. But in the 90% of the cases, it's something that comes at the very end. You gather your intelligence, you gather your information, and then you formalize your request via, well, the tools we are discussing right now, which are the Asset Recovery Office formal network, or the informal one, because there are also informal network that you can count on in our region, which is, for example, the CARIN network, or the judicial way to cooperate between member states, which is the regulation 1805. More or less, we can say that in every member state of current European Union, the judicial system, the investigative system is the same. The difference is that we had were possibly in the common law system, where the police has a more robust power in terms of possibility to intervene with seizures or other freezing tools during the investigations. More or less, it's always up to the judiciary or upon request of the investigators, the police forces, to ask to the judiciary to cooperate with other judiciary body abroad to have a freezing order or a seizure order and a confiscation order. So it's not very difficult when we are talking about judicial cooperation, even if, of course, also in Europe there are some national differences which are, let's say, slowing the process of the decisional process on freezing, confiscation, or seizure order. But I can say that, for example, you have seen that, for example, with Netherlands we have a good cooperation. This is also because Netherlands has introduced during the time a lot of legislative measures which are mirroring in some way the already existing legal framework. For example, talking about preventive measures, like also the possibility of having a lot of confiscation which are not only conviction based but also non-conviction based, and so on and so on. And I also know that in Belgium something is moving on, and this is because, of course, those two countries are affected by drug traffickers in terms of receiving the drug in their ports from South America. So there is also and that's normal, network, logistic network managed by the criminal organizations, which are penetrating the economy and leading directly or indirectly the logistical part through companies and so on to distribute and disseminate throughout Europe drugs, for example, or other illicit goods. And those are, of course, from pure perspective of an external observator, legal companies doing legal business, moving perfectly legal stuff and assets and so on. So talking about the cooperation between police and judiciary, I can say it's a high standard one throughout Europe, also because we have a lot of tools which are permitting us, and when I say us, I of course are referring to the law enforcement agents, the possibility to extend investigation, to perform investigation in other member states, like the European investigation orders, the creation of joint investigation teams, which is another way of using a very effective tool coming from the judicial cooperation and so on. The very, let's say, peculiar moment when we are talking about the possibility of seizing, freezing, tracing, confiscating assets abroad, and with abroad, let's stick to the European Union, is still the lack of an harmonized legal framework throughout Europe. Because we have something that comes at the end, which is the Regulation 1805, which is horizontally applicable for all the member countries. But what is lacking is all the other regulations or laws or directives in the middle. This is what the European Commission and the DG Home is working on, and the approval of the EU directive regulating the new asset recovery offices is a good example of this slow but effective improvement of the legal framework situation throughout Europe to perform a good prevention and a good fight against organized crime. What we have experienced is, in terms of exchange of information, that the quality of information really depends on how AROs are structured. This meaning not if they are only police, multidisciplinary, or only judiciary-based AROs. The most relevant thing is the information and the intelligence they have access to. Because, for example, I can quote my situation. We, as Asset Recovery Office, as Italian Asset Recovery Office, we are only dealing with exchange of police cooperation information or intelligence. This because we already have a very strong asset recovery structure based on the judiciary, on special sections of the courts, and special investigative units from the three main police forces that we have in Italy, namely the National Police, the Carabinieri, and the Financial Police, the Guardia di Finanza. So what was lacking was the point related to the giving and sharing information concerning the tracing of assets, for example. But still, we have access to the 99% of the needed information to have a clear picture of the asset owned by a person, a physical person or a legal person. What we are still lacking, despite the EU Directive 1153 of 2019 and the newly entering into force Directive 2024-1216, is the possibility to have access to the National Banking Register, banking account register. It may seem a bit tricky because, of course, fighting against serious organized crime and Italian police forces or an Italian law enforcement agency is supposed to have immediate access to this kind of information. But still, even if it's managed by Guardia di Finanza officers like me, we are legally considered a third body and not a body dependent from Guardia di Finanza. So we have to write down a specific memorandum of understanding with the managing agency, which in Italy is the income revenue agency. And we are still waiting of the approval of the GDPR Italian authority, which has to grant us the access to these very relevant database. At the end of 2024, we'll have access to it, but we were not entitled to, for example, provide this very relevant information to our colleagues abroad. While other colleagues abroad are entitled to enter those data, but for example, are not entitled to directly have access to cadastral database, or they only have access to police record database, but not to the tax and revenue database, which are fundamental, of course, to trace and to give to the requesting state a very clear picture of it. So it's not about cooperation between police and judiciary. It's the possibility of having access to harmonized information in every member state to are in the position to provide the same information to every single member state, no matter how the Asset Recovery Office is structured. Because still, I don't want to anticipate the topic from Professor Margeri, but still the EU directive will give the possibility to the member state to set up the Asset Recovery Office the way they want. It's not, there's no given structure by the directive, but the directive says, according to the experience made in the past years, that at least the Asset Recovery Office will have, and that's compulsory, minimal access to a list of database, which are the one which are containing data, very relevant data to perform a good picture of the asset recovery situation in the requested state. Plus, there will be, of course, close cooperation with the European Police Agency, which is Europol, which will cooperate with all the ARO network, also with the EFEC, which is a newly created center in 2022, which deals with financial crime. So as you see, there will be a way to perform also a good analysis on the financial and economical part of the fight against organized crime. What I can say is that those problems in terms of efficiency and quality of the data provided by the AROs is reflected in the small number of seizures, freezing and other way to perform the privation of assets to the organized crime shown in the slide. So I'm talking about Italy. We are very effective inside, but we still are facing problems outside. This is a problem linked to the legal framework and to the national laws which are ruling this specific topic, which is the possibility of having not only conviction-based but also non-conviction-based confiscation. And this is something that at European level is increasing in terms of awareness. So it will be up to the interest, to the good feelings about this way of performing a good fight against organized crime that every country will have, that will lead them to introduce this kind of legal possibilities, which I have to say are now clearly stated in different legislations. Again, the EU directive is one of those, because there is a section of the directive dealing with the possibility also of ruling the non-conviction based confiscations, exchange of information, and that's good. So even if a member state doesn't have the possibility, the legal possibility to perform non-conviction based confiscation or preventive measures, still there is a rule, an article stating that just in case, then the procedure had to be performed according to that article. So we are constructing like a Lego, let's say, and harmonized, it will take time, and harmonized framework throughout the European member state, which will help to perform a good fight, not only against organized crime, but also against serious crime, because we do not have to focus on mafia or on other kind of organized crime. There are other forms of serious crime which is transnational or that affects 2 or more member states, which also have to be taken into consideration, and it's perfectly suitable for being, let's say, object and targeted with asset recovery, confiscation, and other preventive and patrimonial measures. So the small number of seizures and confiscations and freezing measures has to be, to say something very positive, also compared with the effectiveness of those seizures, because at least a small number of seizures has led to a significant efficiency and effectiveness in terms of seizures, because every request we have made abroad at least has been successful. So we had a good ratio, a good percentage of effectiveness in terms of request that has been performed, positively performed by the requesting member state, and vice versa, because we have to stress that it's always a win-win situation where the two or more involved states are able to divide into 50-50, according to the 50-50 rule, the value of the seized and confiscated assets. And that's very positive aspects of recurring to this kind of measures. I can say that, and I close my intervention, I see good perspectives in terms of increasing of the numbers of requests, both concerning the Asset Recovery Office network, which, as you have seen, is more or less a police cooperation tool, where also the judiciary is involved, but is more linked to the police cooperation, and the number and the effectiveness of the exchange of requests according to the EU regulation 1805, which belongs purely to the judicial cooperation. I want to bet that in, let's say, a couple of years, we will see the very positive effects of the entry into force of both new regulations and directives regulating the two aspects. So I'm eager to see the same audience here in 2 years discussing on the improvement of both number, effectiveness, and figures about positive results in terms of judicial and police cooperation related to the asset recovery. Thank you so much, and I'm also here for you in case you have some requests or specification you have to ask me to the topic I've discussed on. Thank you so much.
Colonel Ribaldo, what you say is very optimistic because you say in 2 years' time we will have an increase of numbers of us. You hope, we hope, I doubt, but I think that in few words you explain that the low number is due to the fragmented legislation or less harmonized legislation. And you hope that the new directive will, or at least the action of the new directive on the ARO systems, keeping the system as it is, because I don't know, the new directive is really changing the judicial itinerary with the police one. My question is the following to you very shortly. If the output is the same, which means the number of confiscation, seizure and confiscation coming from the judicial or by the police ARO, why not unifying the systems between judicial and police cooperation, giving access to both data coming from judicial? Because on the end of the story, the people go to ARO for investigating and tracing the assets, either if it's coming from judicial or from police. So my question to you in terms of recommendation is why not unifying the AROs and having a double system, judicial and police responding to the different authorities. This will have much more efficiency and less really waste of resources. This is my question to you, and after we will proceed with the Lituan.
Well, it's very easy to be said because there are strong feeling of resistance in changing the structure existing in every member state. So cooperation is better than unification, to be said in one word, because same resistance you will face in Italy. Unifying police and judicial operators is the same you will find in other countries.
Yeah, it's clear.
It's a question of cooperating and exchanging information, not changing the structure. It's a question of mentality, like the introduction of new regulations. That's it.
No,
it's a very.
It's very clear what you say. It requests a lot of work, I think. Well, thanks, Colonel Ribaldo. We go with the next speaker. She is a prosecutor. She is now connected, Miss Ranma, a prosecutor office of Estonia. Thanks a lot for being with us today. You have been interviewed by Matteo, I think, and your answers were really relevant for understanding us the system, how it works. So please, Mr. Randa, the floor, or at least the microphone is yours.
I hope you can hear me.
Yes, perfectly.
Okay, that's good. I will share my screen as well, just to let's see if it works. Sorry. I'm sorry, but I don't think I'm gonna be able to share them. I don't want to waste any time, so I'll just tell you about it.
Could you do one thing? Send to us by mail immediately, and we share for you.
Wait.
Would you do that? Send to Matteo, who has been remembering you the connection.
I'll try that.
as soon as we receive it, we share.
Excuse me, I'll have to look for the. Oh, you just sent me an email. I'll use that.
But I have to look. Okay.
Yeah. Thanks, Colonel Ribaudo. Thank you very much. Bye bye. Have a good lesson. Good day.
Anna si è persa.
So,
Stia attento che abbiamo il microfono acceso. Ora l'ho tolto.
Non c'ho problemi. No, venga acceso pure.
Comunque Eston, non abituale.
Ah, Eston?
Sì. No, ora no. Ah, oddio, ancora sì.
Questi 3-5 anni sotto Putin.
Ecco, no, attenzione.
Io diciamo, col microfono.
I'm just going to reply to the email Matteo sent me, and I hope you can receive from there.
Yeah, I'm updating my mailbox. Should arrive in a moment. I hope.
I hope it's not too big, so it comes through.
Lo sa mandare.
Were you able to receive it?
I haven't received it yet. If you want to begin speaking, I know.
Okay, yeah, I'll begin speaking because I think it's too large of a file, so it's not coming through. But I'll see what my options are to share the information as good as possible without the PowerPoints. My name is Helari Randma. As I was presented already, I live in Estonia, work as a prosecutor here, and deal with international cooperation as my everyday work. I'm a state prosecutor, and today I'm going to tell you about asset recovery and how we do it in Estonia on judicial cooperation level. And I also will speak a little bit about the problems that have occurred and the statistics that we have as well. So for the background of Estonia, just to understand maybe why the statistic is like it is, then Estonia is a quite small country, a population of 1.3 million, and we are the member of the European Union since 2004, and also a part of the Euro area. Our capital is Tallinn, and Tallinn is where most of the government authorities are located. So Ministry of Justice and the Office of Prosecutor General are also in Tallinn. And this is important since the Ministry of Justice is actually the central authority for international cooperation unless provided otherwise with law. So this means that, for example, all the cooperation in criminal matters with third countries actually goes through the Ministry of Justice. As for my obligations, it covers the consultation of our prosecutors. In altogether, we have 170 prosecutors, and in the Office of Prosecutor General, we have this international cooperation unit, and I work in this unit as a state prosecutor. We also have an assistant prosecutor and a consultant there. And as I said, our obligation is to offer any consultation or help with international cooperation that our own prosecutors have. And also we deal with all the incoming requests to Estonia. So this includes all the possible assistance of judicial cooperation, so mutual legal assistance requests, all the European investigation orders, but as well the extradition and surrender cases and any other type of judicial cooperation you can think of. When it comes to assets, then we have a bigger role in the freezing part, but not so much in the confiscation part of it. So we handle the way we handle requests, but the way we handle the freezing requests actually depends on the basis of the requests. Firstly, there are mutual legal assistance requests that actually arrive from third countries and are sent to the Office of Prosecutor General through the Ministry of Justice. And our role is actually to look over everything necessary, if everything necessary is included, and to figure out if we can freeze the assets in Estonia or not. We do this together with our investigative authorities. So we send the request to them to gather information from the banks or currency providers or any asset register that we have in Estonia, and collect all the information together. Then the Office of Prosecutor General draws up a request to freeze any assets that we might find and the other country has requested, and we send this request to court. The court will then decide if the freezing is possible or not. But the most important thing is that these cases are quite hard to figure out, since the law in different countries is quite is not the same, and we have different understandings, for example, about value confiscation or item confiscation, and also then freezing these items or value. And the most importantly, when it comes to mutual legal assistance requests, we have to follow the Estonian law as well. So we have to see if this freezing could be actually done in Estonia as well. With Denmark and Ireland, it is possible for us to use the Council Framework Decision of 2003, and the process is actually quite similar to the one that was described with the mutual legal assistance requests. And when it comes to the best, I think, solution that we have, it's the regulation from 2018. Estonia is using it from the end of 2020. And this regulation is has binding legal force throughout every member state. And it's actually the easiest way to freeze assets. So our role as a prosecutor in the Office of Prosecutor General, in this case, is quite small. We actually collect all the information, as I described before, in cooperation with our investigative authorities. So we send out requests to the banks and cryptocurrency providers or any other registry that is in Estonia. But we don't have to draw up the request to the court. So since the regulation is binding, then we have a different way of solving this, because it's all the court will decide on the basis of the certificate that was sent from the other country, and there's no need for us to draw up an extra request to the court, because they can just use the certificate that was sent from the other country. And since this regulation is binding, then they use the articles provided with regulations, and they don't actually have to find a legal basis to do it from the Estonian national law. But even though it's quite easy to manage this way with the freezing certificates for us, then there are some problems still with the regulations, as in our practice it's come up. Firstly, it's required that before you send out the request to another country, you have reasonable grounds to believe that that there are actually assets that can be frozen in this country. And the problem is that different countries have different national standards for this reasonable ground, and it's not it's not very easy to understand them because they are so different. So, for example, some countries and Estonia as well, we consider that there's reasonable grounds to send us a certificate if this person is our resident or has an Estonian citizenship. But oh, you got the presentation, I see. So I'm in the fourth, I think, part of it. Oh, yeah, fourth slide or sixth. I don't know. Maybe you can find the right slide.
I don't know why it's not. Okay. It's the
see, maybe the seventh slide. Sorry.
Seventh. Okay, yeah. Challenges.
Yeah, challenges with the regulations. Right. So yeah, as I was saying, reasonable grounds. We consider citizenship and residence to be sufficient, although some countries actually need evidence to show that this asset is in their country. So, for example, evidence collected with a search. So, for example, banking documents about an account in a foreign country or something like that. And this is different for every country. So this is one of the challenges that maybe different national AROs can help with, but also this is considered as information, but some countries actually need evidence about it. So it's kind of complicated. And for our prosecutors, we have seen that that they are kind of scared about it. So they want to collect very hard evidence on the fact that there's some assets in that country before they send out the certificate. But overall, in my personal opinion, I don't think it should be that strict, and we should follow the idea that residence or citizenship is actually sufficient to send out the certificate. But in this case, there's also some problems with different understandings about value confiscation and freezing, or with or item confiscation and freezing. But in addition to this reasonable grounds problem, we also have the regular challenges when it comes to international cooperation. So the information presented in the certificates is sometimes not enough. So there are some parts of of the certificates that are missing, or there are different language problems. And with the language problems, we also see that there's not actually enough time to cope with cryptocurrency, especially since the money is moving so fast and it's very hard to track the movements. Then the necessity to translate the certificates is actually very time-consuming, and usually, at least for us, when we execute the requests coming in from another countries, then we can see that that actually the money is already moved away from Estonia and is in a different country. So the only thing we can actually do is let them know that we're sorry, but there's nothing to freeze in Estonia. I would like to go back to the slide number 5, because I think as practitioners, as a practitioner, this is very important. The slide about the European Judicial Network, I hope everyone knows what it is, but it's slide number 5.
Yeah, I'm trying to put it on. Okay. I'm putting it on, but I don't know why you can't display it. I'm sorry. Let's try.
It's fine. Well, I guess it's European Judicial Network, and why I'm telling you about it is actually the fish bilge. And most information about judicial cooperation for European Union countries you can find there. Some countries have updated more information, some less, but the different bases to send out information and certificates are in judicial cooperation is actually written there. And I find it really necessary to work in my work, so to use in my work, so that's why I wanted to share. But as for the statistics in Estonia, since we are quite a small country, we don't have much to show in the statistics, but in the last 5 years, in total, or not in total, like what's the word? In like in 1 year we've sent out about 8 requests on average, and we have received about 20 requests on average, and these cases are mostly connected to different frauds. This means investment frauds, but also computer frauds, but also with money laundering and narcotics cases. And as I said, in my opinion, we should use the certificate or the regulation more in Estonia. Our prosecutors have received training about it, but they are kind of scared to use it. So I hope that this changes with years, and they have more experiences, and they can see that this is a very helpful tool. And I think this is it from me. Do you have any questions?
Thanks, Mr. Radma, for your presentation. It was quite frozen in our screen, but on the end, it's been working in some ways. So we understood that you in Estonia have a quite good cooperation with the local ARO, as I understand.
Yeah. It's very easy, and I'm guessing that it's because again Estonia is quite small, so you actually know the people who work there, and it's easy to cooperate this way.
And it looks also that ARO, the judicial track and the police tracks are cooperating each other quite efficiently. Is it true?
Yeah, in my opinion, yes, they are.
No, your opinion is quite relevant because you belong to the Prosecutor General Office, which is giving the input to the ARO in some ways. So this is really important. It could be possible also that because it's a small population, the problem of inefficiencies don't come out.
Yeah.
It could be, but obstacles in terms of legislations, as you said, there could be. In terms of international legislation, I'm speaking about the legislation of EU member states. You said in your slide on challenges, some countries are making requests with no grounds. This is what you said. This is really astonishing me also. And there are some difficulties but on the end of the story, Estonia has a quite good performance in terms of data, as I remember.
Yeah, compared to population and small states.
It is important to connect the way in which your system is working with the data we have been collecting, because also due to the small population of Estonia, the rate of performance of Estonia in terms of seizure confiscation is higher than the other countries. That means, according to me, that when the system works, the output or the number of is absolutely relevant. Thanks a lot. Thanks a lot. I don't know if there are other questions coming from other partners. So we have 2 minutes.
There is a question. There is a question of a journalist in the chat.
I think it was an observation.
Maybe you can
not
speak
a question.
directly.
I was just supporting the story of Helen. Hilary.
Yeah. As you can see, yeah, it should be sufficient, but people are still having different ideas about it, and yeah, for us, we take it as it's a sufficient basis to send the request.
Yes, I recognized your story from it. For the Netherlands, a place of residence is sufficient. Also, we also encounter that not all member states can deal with this situation yet.
Yeah, but I guess it's because it's quite new. Well, then we just need practice and people to be accustomed to this kind of regulation as well, because it's been very different from the usual mutual assistance requests. So yeah, just takes time, I hope.
Yes, I hope with you.
Okay, thanks, Ms. Radma, for your contribution. We go with the next speaker, which is Androva Bayartova, Supreme Prosecutor Office in Bulgaria. Ms. Radma, if you want to stay connected, it's a pleasure for us to have you here.
I'm sorry, it was a pleasure to attend, but I have other work obligations, but thank you for inviting me, and I hope my presentation was useful.
Okay, yeah. It's extremely useful.
Let me know if you have any questions, but bye.
Bye-bye. Thanks a lot. We proceed with the application of the Ms. Androva Bayarova, Supreme Prosecutor Office of Bulgaria.
She should be connected.
Are you connected?
At least she was connected last time I verified. Yeah, she is still connected.
Anita Androva, are you there? It's your turn.
Maybe, I don't know, maybe she is experiencing some problems with her microphone. I can maybe write her on the chat.
Non c'è. Ormai qui ci sono I puntini.
No, I puntini sono normali. Però I have some technical problems. She has written in chat. Okay. Do you think you can? Maybe we can proceed with some other presentation, the following presentation, and then come back to the prosecutor, I suppose. Or just wait for 2 or 3 minutes.
Wait a couple of minutes when Anita.
Okay. I hope I will manage to solve them quickly.
Questi prosecutor non hanno quell'abilità. It's postponing this presentation of the Professor Scomparin, who is connected, and I don't want to lose the time. We are perfectly in time with the agenda. What we have asked to Professor Scomparin, who has been the coordinator of a project on the same subject of this one, but I don't want to anticipate anything, is to make a comment or a presentation about the results of the other projects, because reading the material the group of Turin has produced, there are many points that could be extremely useful for our projects when we speak about inefficiencies, organizations, and the other things. It is quite clear that the data are very poor. It is also very clear, coming from the Estonian presentation, when the things work perfectly between the Prosecutor General Office and the ARO, things move and the numbers increase. But this cannot be said for all the countries in Europe. I am very happy that Professor Scomparini is connected together with us. She has accepted our invitation, and I'm very interested in listening to her comments about the results of her projects, especially dealing with the inefficiency of the obstacles about the regulation. Oscar Calavita is also connected to the University of Turin. Both are part of the same projects. Laura, please, and Oscar, the floor or the microphone is yours.
Yes, thank you very much. Just a few words of introduction, because I would like to thank you for asking us to speak at your workshop, and also thank you for your words. We are happy to be here, as I strongly believe that collaboration in European research is essential, and somehow research projects do not end when they formally end. I mean that the dissemination of the results is equally important. So you asked that short presentation of the recently concluded FORCE project and the results that may interest your research, so a part of our research. Oscar Calavita, who has been one of the pillars of our works of the past 2 years, prepared a short PPT presentation, and so he will now try to illustrate I would say, the highlights, answer, I hope, any questions you may have. So, Oscar, the floor is yours.
Thank you, Professor. Thank you for the invitation. Let me just try to share my presentation, but I'm not used to Teams, unfortunately. And condividi, here it is. So, okay, I have to open my presentation from here. Okay, so University FORCE presentation. Here we are. Share. Okay. Okay, can you see my presentation now?
Arriving, I hope so. Yes, now yes.
Oh,
FORCE.
okay. Okay. Thank you very much. Presentation. Start presentation.
Full
Here we are.
screen.
Yeah.
Is it full screen now?
No, it's not full screen at the moment.
No, but sometimes there are some problems with that. But
Perché devo cliccare sul full screen?
I won't put it on full screen. Let's leave it like this. You can see it. So here we are. Just a very brief overview on the FORCE project. We had the goal of improving judicial cooperation in the recovery of illicit assets. The goal is the same of yours. And this general objective was declining specific objectives, which were to remedy to the lack of knowledge in the EU cooperation concerning the regulation, to fill the gap of harmonized rules, and to ease the cooperation regarding freezing and confiscation orders. And in this project, we can say the project can be parted in 2 phases: an explorative phase, which were a phase of research, which was composed of the desk research, which means a research, a study on the national legislation, and a more concrete research concerning interviews with selected practitioners. Both the desk research and the interviews came out with a deliverable, which were comparative reports. Then, from the explorative phase, we got to the proactive phase, creating an online database, some mocks, and most importantly, our set of recommendations, which were called force common standards and recommendation, which in sum, to cut a story short, are the guidelines of we proposed for the application of the regulation or the freezing regulation. The desk research involved all the countries bound by the regulation. It means all the countries of the European Union, but Ireland and Denmark, and led to the comparative report on desk research. From this desk research, we found out, first of all, that even if the regulation should be directly applicable in every member state without the need to be implemented, however, almost all member states felt the need to introduce specific regulations, both by introducing hard laws, by using hard laws, or by using soft laws, in order to prepare the domestic legislation to host the regulation or to try to facilitate the application of the regulation. These were the objectives of the national legislation, but here we can see that they introduced both special laws or amended criminal codes, criminal procedure codes, or other laws which were focused on criminal cooperation. And we can see here that the most common area of intervention are more than one. In green, you can see the area of intervention, and in red, you can see the problems that could arise from the intervention of the legislators. If for the competent authorities, issuing authorities, recognition, execution, there are no problems, because indeed also the regulation needs an implementation regarding which or what authority can issue or execute an order. The problem relate to the document contents, because, for example, some member states required a copy of the original order and some other didn't. Indeed, the regulation allows member states to require the copy of the original order, but a uniform application would have smoothened the cooperation in order to avoid one issuing authority to transmit or not transmit the original order to one or to another order. All the other problems regarded the communication channels, because we had problems with email. Someone stated email is sufficient, other use telefax or electronic mail, certified mail, that were a problem, even if now this problem should be a little bit solved by will be, we hope, solved by the general application of the e-codex regulation, which has been made mandatory by the regulation concerning the digitalization of justice. Here, another point, timing had no problems. Languages, on the contrary, had. Languages is one of the most difficult problem to solve, which came out from the interviews with practitioners. Indeed, generally speaking, now we have no problems in translating from a language to English. However, not every member state accepts, or better, only a few member states accept English as a language authorized to transmit the order. The most of the member states only accept their national language, and this is indeed a problem, because, as I said before, if it is not a problem to translate an order from Italian to English, from French to English, from maybe Latvian to English, the point is whether we have to translate from a language to another which is not of common use. We can think to, I don't know, Greece, Estonian for Italy, or from Italian for Estonian people. You can say here the problem is there is a lack of translators. Practitioners experienced a lack of translators, experienced loss of quality in the translations due to a double translation from the native language to English and then from English to the final language, which can cause problems and misunderstandings in both the translations. So the problems, theoretically speaking, and also practically speaking, doubles. Then we have the grounds for non-recognition and non-execution is another topic in which member states intervened, and this is quite a problem because the regulation, and as we know, the Court of Justice stated that grounds for non-recognition are only those provided for by the European instruments, in this case by the regulation. They must be of strict interpretation, and member states cannot introduce new grounds for non-recognition. However, some member states introduced new grounds, such as Malta, for example, that provided that the foreign confiscation order is based on a manifest error of law or fact. This should be a ground for refusal, and it should be disapplicated. And other member state wanted to implement, to translate, to reproduce the grounds for non-recognition, but either they reproduce only a few grounds or they reproduced it in a bad way. And this could be a problem in cooperation indeed. This can hamper mutual recognition and could hamper mutual trust. Other problems are related to the compliance with offenders and third parties, but this is a problem which borns from the regulation because the regulation provides in its Article 34, if I'm not mistaken, only and cannot be otherwise a general overview on remedies. Therefore, member states had to implement and general remedies in their national legislations. If those were the problems encountered at a general level, at a legislative level, then we had a phase in which we kept in touch with the practitioners and academics. With the interviews phase, we interviewed 63 practitioners from 15 member states. We had many operative hurdles due both to the difficultness to reach practitioners and their reluctance to be interviewed. And this difficultness is due to a lack of application of the regulation. As Matteo pointed out before, the first 2 years, 21 and 2022, showed very few applications of the regulation. We can say also in 2023, because I asked for some more data to the European Commission, are more or less the same. So we have very few orders issued and recognized or executed. It was one of the operative hurdles. And then together with the interviews phase, we had consultation sessions with academics and practitioners in order to validate our common standards and recommendation. Maybe I didn't see that the interviewees were most of them magistrates and only 11 were lawyers. General findings, practitioners believe that domestic hard and soft laws are useful to use the regulation. This is the first finding we met. They also believed that Eurojust and the European Justice Network have an important role in helping judicial authorities to talk together. And we saw that the channel used to transmit the orders were both email, fax, the Eurojust, the Siena. But as I said before, we'll see in the future if the e-codex regulation will smoothen the transmission and the application of the regulation. And as other general findings, we can say that not many of the interviewees, which are both lawyers and magistrates, experienced remedies, only 7 up to 63, and no one reported the ground for refusal, the application of the ground for refusal concerning double criminality and fundamental rights clause. Some problems experienced by the executing authorities are that difficult to check the maximum sentence of another member state because maybe it is not filled in the form. And the most of the problems, but languages, which just talked about before, are problems with the certificates because many times the certificates are incomplete. They are transmitted without using the form attached to the regulation. There are mistakes relating to the location of the property, and sometimes it is indeed the wrong instrument that was used. For example, an EIO was issued and transmitted to freeze a good, but it was not the EIO that should have been issued, but it was a freezing order according to the regulation. Main obstacles for the cooperation in general, not only for magistrates, are the rigid structure of the form. Again, it comes again the problem of the form, the lack of relevant information in the form, so the incompleteness of the form, lack of meeting, training, and experience of magistrates. It means magistrates need more training on this topic because mutual recognition instruments are not so used in the practice. And on the side of lawyers, we encountered a problem on the working of the mutual recognition instruments because sometimes the lawyers we encountered were not so used to the mutual recognition principle, and they wanted to celebrate a new process in the executing state, even if that's not the field in which to celebrate a process, because as we all know, the substantive grounds are to be appealed in the issuing state. Lawyers had problem of lack or encounter problem of the lack of access to documentations, and on time limit, they think that a time limit for freezing order should be provided for by the regulation and by every national pieces of legislation. And I'm going to finish my intervention. Our guidelines, our common standards were grounded on 4 pillars: the minimum use of grounds for refusal. Before refuse an order, the dialogue is the most important way. We have to recognize as many orders as possible and to assess the principles of necessity and proportionality. Here are the contents of our CSR, which you can find online on our website, which is projectforce.eu. Some problems were concerned the meaning of criminal proceedings in criminal matters, and Professor Maugeri well knows this problem. She wrote a lot on this topic, so we can skip the problem of proceedings in criminal matters. Here is the last point. It is my last slide. All types of orders. To recognize all types of orders, because recital 13 says that proceedings in criminal matters therefore cover all types of freezing and confiscation orders, even if such order might not exist in the legal system of a member state. They should always be recognized, even if a member state does not provide those specific freezing or confiscation order. The most sensitive issue was related to non-conviction-based confiscation and to confiscation of unexplained wealth, such as Italian misure di prevenzione. We have to look at the future and to see if these problems could be solved by the new regulation 2024-1260, because it harmonizes at least partially the confiscation orders all along Europe, with the provision of no confiscation based, even if in some specific ways. It provides for confiscation from a third party, the extended confiscation, and the confiscation of unexplained wealth. I hope to have been clear. I'm sorry to have rushed, but I had many things to say in a short time, and thank you for your attention.
No, thanks, Dr. Calavita and Professor Scomparin. We lost in connection a few slides, so if you could send your presentation, this will be extremely useful for reading it. As you know, the system we have here in Transcam Milan has been cracked by some cyber attack or something, I don't know. But on the end, my question to you will be helping me to understand a little more. If somebody is asking you and Professor Scomparin, according to the experience of your research force, to explain in 2 minutes what works in the regulation, what doesn't work, and what is promising. Can you answer summarizing in few items? So what works, what doesn't work, and what is promising? I know that I'm asking you to summarize a lot of information, but this could be extremely useful, because you said, for example, in the beginning, that translation is a big issue, but with ChatGPT, I am really surprised that translation is becoming a very
also
big
in our
problem.
research we meet this problem, Ernesto. Also in our debate about the problem in the implementation of the regulation, this problem of the language is a common problem, even if it is strange, because in 2024 there are also very good system of translation, or the other solution can be the English for to accept the English text. This was also a proposal, if I don't make a mistake, of Netherlands, no, about the proposal in order to solve these problems. No, this is not a real problem, but in the practice, it is a problem. This is strange, but also we meet this kind of a problem, no?
Okay, translation is a big problem. After that, so many other problems about obstacles.
Yeah.
Maybe, I don't know if Professor Scomparin wants to answer. If she doesn't want, I can answer. Ubimayor. Okay. We can say, from our experience in the practice with our interviews, the 2 main problems were languages I don't know why, but are languages. And if you think some artificial intelligence software indeed keeps data to improve the database, that could be a problem regarding right privacy, but it's another topic. For practitioners, the problems were language and certificate. The certificate is one of other issues because they have many problems in the filling of the certificate, in the use of the certificate. We can say, moreover, that there is a lack of knowledge of this instrument in specific, but also of mutual recognition instruments in general, and how the mutual recognition principle works. This is the ground topic, because if
Training.
if the practitioners are not used to mutual recognition principle, it is indeed a problem. And these are the most important problem, we can say, in practice, because more or less no one experienced the use of ground for refusal, but in the people we interviewed, because we see that in data collected also by Matteo, there were some refusals, but we hadn't met any practitioner on it. And on a legislative framework, problems can regard the grounds for non-recognition and non-execution. To cut a long story short and to extract some pills from our experience, problems are practical problems.
Oh, sorry, if I can add just one word. I think that our main result is that, can you hear me?
Yeah, perfectly.
Okay, sorry. That you don't do them because before, the problem is you don't do them, not you don't execute them. There is a sort of previous problem, this lack of awareness of the tools available. I mean, you don't use them, you don't do an order because you don't know the instrument. You think that it's a complicated procedure. In your judicial office, only one person deals with this kind of instruments. They are not tools on which all judges are competent. So this is my general overview of the problems that we met. And I think this is a big challenge for European Union. It's not only a problem of legislation. We can study the directive, the regulation, and all the issues related to from the point of the legislation. But I think that legislation is not perfect. We have pointed out some problems, but the main problems is that you don't use the tools because you don't know it.
This is really very important. I think it's a very relevant conclusions about the ignorance of judges and prosecutors in using the tool.
It's not their fault. I mean, sorry for the judges and the prosecutors who are here. No. It's not their fault.
What you say is confidential, but I was assuming that one of the main reasons, there are many, legislation, translation, competence, and blah, blah, there is really also this, the people are not capable to use the tool, or people to whom the tool is directed, which is a part of the culture of the international cooperation, which means still many countries are below relevant standards about international cooperation in the area of judicial matters or police matters. It could be possible also that police matters are Police AROs are much more efficient than judicial ARO, but this is another story, completely different. But could you envisage what is promising, that the competence will increase? Laura, do you think that in the future there will be an increase of competence?
I think that the main problem is to create a new generation of judges and prosecutors. I mean, the real thing that you can do in Europe is to create a real integration. I mean, the cooperation within judges and prosecutors as persons and not only as instruments.
Yeah.
This is a crucial point that it's not for
training.
Maybe it's not the main issues for a criminal lawyer because it involves other kind of skills, but I guess this is the real problem nowadays.
Laura, it is here I was invited two times by the School of for Judge, Italian School for Judge, in order to speak about the regulation, the mutual recognition, the harmonization. So the challenge for the future is the training of the law enforcement, the public prosecutor, the judge, in order to increase this awareness, the knowledge of this instrument. And in the end, this is also the aim of our projects, no? You have prepared this kind of a training course online, if I have correctly understood. This is a very good instrument. We have involved in our project many prosecutor office and try to organize also activity of dissemination, also with the websites, you and you. So it is the challenge for the future. But what is also interesting, some specific in your presentation, or in the presentation of Oscar, there are some specific ground of refusal, for example, which are interesting. The lack of remedies. This is strange, no? Because this is fundamental, no? This is a good ground of refusal, the lack of remedies, because in each European instrument, one of the most important elements is that the remedies have to be available, no, in order to guarantee the right of defense and so on. So it would be interesting to know which countries in which system of law in Europe there is this lack of remedies. The wrong contents is a problem of training of the author of the certificate, in my opinion. Also, in our experience, Dr. Lotti, she's a prosecutor in Rome, who has a very good experience in this matter. In his experience, in many certificates, there are not enough elements of the crime, elements of the illegal origin, no? Because the idea is that in Italy there is the preventive confiscation, so it is possible to send a certificate without a good basis, no? This is absolutely wrong, no? For example, but this problem is possible to overcome in the future with a good training. The lack of remedies is a structural problem of a system, no? And also this new ground of refusal, this is not possible, no? On the basis of the regulation. This is a refute of the European approach, of the mutual recognition. So the European authorities can't allow the introduction of a new ground of refusal. This is also a big problem, no? In my opinion, in order for the problem of the non-conviction based confiscation, the future is not Article 15, because Article 15 demand in any case a criminal proceeding. when it is not possible to conclude the criminal proceeding, but the basis is always where criminal proceedings have been initiated but could not be continued because of one or more of the following circumstances. So the Article 50, non-conviction based confiscation, in the end is not a action in rem, is not a real non-conviction, no, a real is not the model of our preventive confiscation. The challenge can be Article 16, even if in the end it is more limited in the sector of the fight against organized crime. But only, in my opinion, the model of confiscation of Article 16 is an action in rem. No, is a real non-conviction based confiscation out of the criminal, the traditional criminal trial. No, so it is the. Thank you so much for your presentation and to share with us the results of your project. This is very interesting for us. It is a good way to improve our research. Thank you so much.
So, Laura and Oscar, if I can call you, thanks a lot for this contribution. Really, I know that the project has been concluded, so we will read your material through your website. If you could, Dr. Calavita, send your presentation, or probably we do have it.
You already sent them, I think.
Okay, good. This will be collected by us.
Right now.
By now, okay, fantastic.
I sent it in real time.
Okay, real time.
Thanks.
So thanks a lot once again, Professor Scomparin and Dr. Calavita. We go on the next presentation, which was postponed by Bulgaria, Ms. Sandrova Bayarakova of the Supreme Prosecutor Office of Bulgaria. I'm sorry if, yes, our video is completely distorted, but in the break, we will switch off the computer and start again. We have some problems with the video camera. Go ahead, Ms. Bakarova.
Dear colleagues, I would like to, first of all, to thank you for the opportunity to be a part of the workshop today. We had some technical issues here, that's why we could not make the connection. Actually, now I'm connected to my mobile phone. I hope the connection is good. Our IT specialists are trying some new security system. That's why we have some problems with the internet. As I was presented, my name is Anita Androva Bayrakova, and I'm public prosecutor from Bulgaria with almost 20 years of working experience as a public prosecutor. I work at Sofia City Prosecutor's Office, and since March 2021, I'm seconded at the Supreme Prosecutor's Office, the International Department. So in my presentation, I would like to draw your attention to some of the new amendments and procedural legal changes connected with the application of the regulation, which I find as sufficient. And then I will give an overview of the application of the regulation by the asset recovery offices. I will share some statistical data for the management and the social reuse of frozen and confiscated assets. So the regulation on the mutual recognition of freezing orders and confiscation orders is the first legal act which has direct effect in the area of mutual recognition within the framework of criminal proceedings. I should also mention here the new regulation 2023-1543 of the European Parliament and of the Council of 12th of July 2023 on European production orders and European preservation orders for electronic evidence in criminal proceedings and for the execution of custodial sentences following criminal proceedings, because the European legislator has adopted a regulation instead of directive, which needs to be transposed into national legal systems. It is also very significant, especially considering the new forms of criminality, which are becoming more and more transnational, and we need working mechanisms for fast judiciary cooperation to be able to investigate such new forms of criminality. The regulation on mutual recognition of freezing and confiscation orders aims to optimize the procedures for the mutual recognition and also to facilitate cross-border recovery of proceeds obtained through criminal activity in the European Union. It is based on the understanding that seizure and confiscation are among the most effective measures of preventing and fighting crimes, including terrorism and organized crime. In addition to the extended scope, the application also ensures the effective protection of the right of the victims of crime to compensation and return of property. To ensure the effective implementation of the regulation, the Bulgarian Parliament introduced some legislative amendments. These amendments were made in the two legal acts transposing framework decision of freezing of property and framework decision 2006-783 on the application of the principle on mutual recognition of confiscation orders, i.e. the two framework decisions that were replaced by the regulation. The amendments in the two specialized Bulgarian laws mainly aimed first to define the national authorities competent to function as issuing and executing authorities according to the definitions of the regulation, regarding seizure acts and acts of confiscation to determine the proceedings before the competent authorities, the procedural rules, and to determine the procedures of appeal. As provisions of the two mentioned framework decisions continue to apply between member states not bound by the regulation, Denmark and Ireland, and between the member states bound by it and any member state not bound, the legal approach that was chosen was the one that allowed the integrity and the structure of the laws to be preserved to the maximum extent to which many years of jurisprudence refer. So let me turn to the implementation of the regulation by the asset recovery offices. In accordance with Article 28 of the regulations, new provisions have been introduced related to the management of the secured, of the frozen property. And the national authority to which it is assigned is the Commission for Illegal Assets Forfeiture, or the Commission for Confiscation of Illegally Acquired Property, which was the translation of the term before the amendment. The new translation of the name in English is Commission for Illegal Assets Forfeiture, or I'll just call it the Commission because it's too long. So the Commission is also the national authority with powers regarding the management of property secured under the Order of Criminal Procedure Code in national criminal proceedings. A positive new element of the provisions contained in the regulation is the guarantee of priority for the return of property to persons injured by a crime, both in the cases of secured property and that of confiscated property, Article 28 and 30 of the regulation. The provisions of a national measure to ensure the return of property at the collateral phase is necessary, including in view of the proposed assumption of the functions of management and custody of the collateralized property by the Commission. On the other hand, Article 30 of the regulation can be applied by the national authorities, the competent courts, and the National Revenue Agency, even without introduction of special measures. According to Bulgarian legislation, structures related to asset recovery procedures in general are Commission for Illegal Assets Forfeiture. Their competencies within so-called civil confiscation. Prosecutors' offices of the Republic of Bulgaria have competence in criminal proceedings when confiscation is one of the punishments provided for a crime committed. The National Revenue Agency, which has a major role in collecting taxes and social security contributions, as well as implementing measures to collect areas and recover assets. Ministry of Interior, the General Directorate of National Police, there are specialized departments that deal with financial crimes and support the identification and the investigation of illegally acquired assets, activities related specifically to the acquisition of assets. State Agency for National Security has specialized departments that investigate cases of money laundering, financing of terrorism, and other financial crimes. In the aspect of the regulation, the National Centralized Office responsible for the management of frozen property with a view to possible later confiscation, appointed by the Bulgarian legislation, is the Commission for Illegal Assets Forfeiture. The National Centralized Office responsible for the management of confiscated property is the National Revenue Agency. The Commission of Illegal Assets Forfeiture is an independent, specialized standing state body for the implementation of the unlawfully acquired assets forfeiture policy. The Commission is a public finance legal person seated in Sofia. The activity of the Commission is assisted by administration, which is included in the territorial units of the Commission, which have the status of directorate. The activity of the Commission in seizing and confiscating for benefit of the state assets required from illegal activities carried out through so-called civil confiscation or non-conviction-based confiscation in civil proceedings before the court. If there is data on property acquired abroad, assistance might be requested by the Commission from the International Cooperation Unit. The Commission interacts with other institutions from other EU member states through the International Cooperation Unit. The information is requested from other countries and their asset recovery offices regarding persons subject to verification by the Commission authorities. The Commission initiates an unlawfully acquired assets forfeiture proceedings in certain cases appointed by the law when a reasonable assumption can be made that particular assets have been acquired unlawfully. There is a legal definition of the term reasonable assumption. It is supposed to exist when, after an examination, a significant lack of correspondence is found in the assets of the person under examination. Significant lack of correspondence exists when the assets and the net income exceeds 1,500 leva. This is the Bulgarian currency. For the entire period under examination. So management and social reuse of secured and confiscated assets, Interdepartmental Board for Management of Forfeited Assets is a part of the specialized administration of the Commission. The board is a collective body which consists of deputy ministers designed by the Minister of Justice, the Minister of Finance, the Minister of Economy, Minister of Labour and Social Policy, and the Minister of Regional Development and Public Works. The board is chaired by a deputy Minister of Finance. The administration of Ministry of Finance ensures the technical support for the operation of the board. The specialized administration carries out functions of management, storage, and protection of property on which security measures have been imposed in the proceedings initiated by the Commission. According to an amendment made in 2018 in the Bulgarian Criminal Code, the property secured in national criminal proceedings for the purpose of confiscation is also managed and guarded in the accordance with the Unlawfully Acquired Assets Forfeiture Act by the Commission. The National Revenue Agency is a specialized state body under the Minister of Finance for establishment, securing and collection public claims and private state claims specified by law, as well as a body for managing and disposing of confiscated and abandoned assets, state property. The National Revenue Agency is also the national centralized office responsible for the execution of district court's decision for recognition of a confiscation or seizure order issued by another member state on the grounds of regulation. Any order recognized in accordance with the procedures shall be transmitted to the National Revenue Agency for execution in accordance with the procedures specified in the National Revenue Agency Act and Tax and Social Insurance Procedure Code. The National Revenue Agency shall immediately inform the corresponding state, the corresponding court actually, of the actions undertaken to execute the order. So I would like to present some statistics on the types and values of assets currently managed by the authorities responsible for secured and confiscated assets. Summary information on the values of the assets except for safekeeping by the Commission by the date 1st of June this year. According to the statistic that was presented to our office by the Commission, the total amount of property that is accepted for safekeeping is over 24 million level. It's 86,912 level, which is divided into motor vehicles, cash, securities, movable items made of precious metals. All items are divided, their value, the type of the property and the value. This is the whole amount of the value that is accepted for safekeeping. And summary on the statistics that we received from the National Revenue Agency by the date of 5th of June this year. The National Revenue Agency manages confiscated and seized assets in criminal cases in 9,587 items, of which 5,031 items are weapons, ammunition, explosives, and pyrotechnics, 18 immovable properties, and 1,544 motor vehicles. The agency has no assets seized in criminal cases that require management through international cooperation. In cases in which a confiscation act issued by a member state of the European Union and recognized as enforceable in Bulgaria is executed, correspondence is conducted with the competent authorities of the member state with a view to making payment. According to the statistical data that has been presented to us by the National Revenue Agency, the agency has received 5 acts issued in member states of the European Union, recognized as enforceable by the competent Bulgarian district court, according to which decisions immovable properties and sums available on bank accounts were confiscated. The acts have been executed and 50% of the sums received from the assets have been transferred to the accounts of the member states of the European Union. Transparency for the management of confiscated and state-owned assets is guaranteed. The National Revenue Agency maintains a public register of confiscated and state-owned real estate, which contains information on the stage of management and disposal thereof. In addition, sales of confiscated property are conducted through public auction sales. Valuation of the items is carried out at market prices by engaging an independent appraiser. The sales of confiscated property and confiscated property for the benefit of the states are carried out in accordance with the tax and insurance procedure code through an auction. Sales are publicly announced, bidding is done in secret, the properties are awarded to the highest bidder. According to the information received from the agency, there are no exact statistics on the average time between the confiscation of an asset and its sale, but usually movable property is realized within 3 to 6 months and immovable property up to 1 year from receipt of the deed in the agency for execution. There are items for which there is no interest and cannot be sold quickly. For example, old motor vehicles with administrative restrictions on driving and registration. At least 30% of the value of the property seized for the benefit of the state is issued for social purposes, the terms and conditions being determined by an act of the Council of Ministers. The sums from the realization of confiscated and confiscated assets in criminal cases in Bulgaria are contributed to the revenue of the judiciary in accordance with the law on the state budget of the Republic of Bulgaria. The sums received from the realization of confiscated assets under the regulation are distributed according to the provisions of the regulation in ratio 50-50 between the Republic of Bulgaria and the relevant EU member state. If they exceed 10,000 euro, the sums intended for the Republic of Bulgaria are included in the income of the Republican budget. Procedures for providing budget organizations with confiscated assets are carried out in the National Revenue Agency within the framework of the national legislation, but at the moment there are no cases of assets used by the community on the grounds of the application of the regulation. Within its competence, the National Revenue Agency has a partnership with the National Commission for Combating Trafficking in Human Beings, providing upon request information on confiscated assets with a review to the possibility providing them to the victims of crime. So thank you for your attention. It was in brief my presentation about the implementation of the regulation by the asset recovery offices.
Thanks a lot. Could you send, is it possible for you to send the data you have been speaking about?
Of course, I will send you the statistics, and we have maybe in our final report it will be also summarized all the statistics. But I may send to you after the presentation. I may send it to you in written because.
Thanks a lot for your presentation. Now we have one option, having the speech of Professor Malgeni before, but we are late, or we go to the break and Professor Malgeni after. Professor Maugeri, do you prefer to speak now before the
For me,
break?
it's the same. Maybe for the colleagues, it is better to have a pause. For me, it's absolutely the same. But I don't know if they are too tired.
Without the coffee. Great majority. Okay, let us do one thing. A coffee now, 20 minutes, sharp, and let us see, 11:30 sharp, we rejoin the connection and with the intervention of Professor Maugeri, which will last 20 minutes. Okay, thanks a lot. See you in 15 minutes on 11. Thanks a lot once again, Madame Andova. Ok.
Thank you.
Okay.
Provate a ristabilire la connessione.
Ok. So best fast cricket. Perfetto. Piccola prova. Piccola prova.
Okay.
When you want, I can start.
Yes, 1 minute.
Yes.
Professor Maugeri, maybe you have to lower a bit the camera because we can see entire your face, completely your face. No,
Can
the
you
opposite.
see the slide?
Yes, the slide we can see them, but now we
Okay.
can see just your front in your face. No, okay, that's right. Okay,
Is it
fine.
right?
Fine, so
Okay.
right.
Okay.
The video is okay, the audio is okay, the coffee is okay. Professor Maugeri, you have 20 minutes.
We had maybe the intervention by Correa that had raised his hand in the previous session.
But is he connected?
If
think so.
Correa has a particular problems, we can postpone my presentation.
Joao, are you online?
Yeah.
Okay, could you put your question?
You're on mute, I'm sorry.
No, mute. No.
Good morning.
Yeah.
Good morning.
Perfect.
Sorry.
Yeah, now he...
It was at the time. It was just to stress the opinion of Professor Laura, Professor Laura. So Scaparini. So it's not now it's not update anymore. So please, Professor Maugeri, proceed. Thank you very much.
Okay, so can I start?
Yes, you can start. Thanks a lot.
Okay, perfect. Thank you so much. Thank you so much, Professor Savona and Matteo, Laura, for the organization of this workshop about this other subject in our project about the Asset Recovery Office. Today, I would like briefly to stress the new role, the improved role of Asset Recovery Office in the new directive on asset recovery and confiscation of this mistake of 2024. In the regulation, we can find only in the recital 54 a rule about the Asset Recovery Office. Member states should ensure their Asset Recovery Office cooperate with each other to facilitate the tracing and identification of the proceeds and so on. The importance, the problem connected with the activity of the Asset Recovery Office is stressed also in the Commission work program for 2021-24, where was announced the intention not only to revise the directive, but also to introduce a directive on Asset Recovery Office, which should replace Framework Decision 845 of 2008, in view of the limited successes still recorded in the confiscation of criminal proceedings in Europe. In this work program, it is stressed, although as the ability to freeze and confiscate assets depends directly on the capacity to trace and identify them, The specific objective of the initiative is to strengthen Asset Recovery Office and to reinforce EU cooperation. The Commission's report Asset Recovery and Confiscation, ensuring that crime does not pay, and the previously commissioned studies on the implementation of the directive showed some potential areas for improvement of the Asset Recovery Office. Because it is stressed the pure result attributed to the malfunctioning of Asset Recovery Office, which currently have limited powers to identify and trace criminal assets. It is conveyed that these offices have limited information at their disposal. They have insufficient operational powers, inadequate financial, human, and technical resources, and also the degree and the quality of the training courses is deemed deficient. They are often not sufficiently involved in confiscation proceedings and encounter problems in financial investigation. The regulation imposed on this office for the protection of personal data are not in line with the Data Protection Policy Directive. Not only, but despite the fact that Article 11 of the directive, of the old directive, required the member states to collect statistical data on annual seizure and confiscation order on the value of these assets, data collected are limited and not comparable, and the Asset Recovery Office often don't have access to this data and those of other states, and this, together with the lack of a centralized European database, prevented them from knowing whether certain assets have already been seized and confiscated by other member states. The first idea was to introduce a separate directive. In the end, the choice was to introduce some rules about Asset Recovery Office in the new directive of 2024, also with the new models of confiscation, freezing order and confiscation, and also with the rule about the Asset Management Office. The bringing together in a single act of obligation previously spread over several instruments would ensure a more coherent and strategic approach to asset recovery and cooperation of all competent actors in the asset recovery system. The replacement is also established in Article 36, the replacement of the framework decision 845. So, in the new directive, it is stressed in Article 4 the importance of asset tracing investigation, the obligation of member states to improve asset tracing investigation when an investigation is initiated in relation to a criminal offense that is liable to give rise to substantial economic benefit, at least within the framework of a criminal organization. In the European Parliament inserted also a rule in order to include the restitution and compensation of crime victims among the purpose for which asset investigation might be triggered. But this rule was not introduced in the end, only in the recital 37. Asset Recovery Office. So, in the recital 16, we find an important clarification. In the opinion of the European legislator, the member states can include in Asset Recovery Office representatives from both law enforcement and judicial authorities in the staff, or establish a Asset Recovery Office both within law enforcement authorities and the judiciary. So there is no obligation of asset recovery as judicial authority or law enforcement, but both these officers are admitted. The problem is the relation with this asset recovery office with judicial authorities. In Article 5, the obligation of each member state to introduce at least one asset recovery office is established to facilitate cross-border cooperation in relation to asset tracing investigation. For the first time in this rule, the specific tasks of asset recovery office are established. To trace, identify instrumentally proceeds of property, necessary to support EPO or other national competent authority, to trace, identify instrumentally proceeds which are or might become the object of a freezing or confiscation order, to cooperate and exchange information in other member states and the EPO. It is important in order to perform the tasks to request the asset recovery officer should be entitled to request the relevant competent authority to cooperate with them where necessary. So there is always this principle of proportionality where necessary. It is important that the asset recovery office, on the basis of Article 11, must have the power to take immediate action pursuant to paragraph 2, where there is an imminent risk of the disappearance of the property that those offices have traced and identified on the basis of Article 5. Number 2. Immediate action, what means shall be taken where necessary in order to preserve the property until a freezing order has been issued. But member states shall limit the temporary validity of that immediate action. So this is very important because this is an attribution of a very important power that it is an immediate measure, is a kind of a pre-freezing order. Also in the recital 22, it is admitted that this power to take immediate action. In our work package 3, by Romania, some arguments emerged in favor of the competence of asset recovery office to take immediate measure. Because AROs has access to the national register, containing the set and the freezing of these assets for a short period could be carried out immediately. In terms of international cooperation, it would eliminate administrative obstacles caused by the lack of communication between the competent authorities of different member states. The AROS structures have developed a secure and constant channels of communication, which are a real advantage in terms of providing the fastest possible support. The financial information is provided by the AROS structures on the basis of Article 6 and Article 9. Taking immediate action on the assets just identified during the cooperation is the option that ensures the greatest coherence of the entire architecture underlying the financial investigation. But in the recital 17, it is established that there is no obligation to recognize such order immediate measure on the basis of the regulation 18.5. Okay. In any case, competent authority also in the directive can also introduce the freezing order, also competent authority that are not judicial authority. Okay, on the basis of Article 5, asset recovery should be also empowered to apply to work also in the cases of the application of the directive of the mutual, also the mutual recognition in case of the violation of the union restrictive measures. It is emphasized in this number 4 of Article 5. Article 6, it is very important because it establishes the member states should ensure the State Recovery Office have access to the information. One of the problems of the malfunctioning of a State Recovery Office until now has been the limited access to the information. So Article 6 establish the obligation of member states to give access to a lot of information to the extent that such information is necessary, always the principle of proportionality. Immediate and direct access, first of all, access to information which are included, stored in centralized or interconnected database or registers held by public authorities. The Consiglio has wanted this specification. So there is this list, also centralized bank account, national beneficial ownership, and so on. There is also another list, number 3, which include fiscal data, national security data, crypto assets, also business information system, and so on. But it is specified that where the information is not stored in centralized or interconnected database or register held by public authority, member states should take the necessary measure to ensure that a State Recovery Office can swiftly obtain that information from a relevant institution by other means. So not only in information in database held by public authorities, but it is also possible to take necessary information with other means. Member states might decide that access to the information referred to in paragraph 3 requires a reasoned request. So there is a kind of obligation to better motivated the request about the information in paragraph 3. Reasoning the request, that such request can be denied where the provision would jeopardize the success of an ongoing investigation, be clear disproportionate, compromise information provided by another member states or third country. In any case, procedural safeguard must be respected and, where necessary, also a judicial authorization. In recital 18, it is specified it is a necessity to respect the procedural safeguard, but it is also affirmed that the implementation of a procedural safeguard should not affect the ability of a State Recovery Office to respond to requests from other member states, especially in the case of an urgent request. So there is this necessity to balance the procedural safeguard and the necessity of efficiency of a State Recovery Office. In any case, the directive set minimum rules, minimum standards, and member states at the national level have the possibility to grant a State Recovery Office access to more information. In Article 7, the conditions for access to information by State Recovery Office are established. There is always, it is a case-by-case basis, also on the basis of a principle of proportionality, only where necessary and proportionate for the performance of the task. In any case, member states shall assure that the staff of a State Recovery Office comply with the use of confidentiality and professional secrecy, have specialized skills, appropriate technical and organizational measures have to be taken to assure a level of security. Article 8 is important because also establish a monitoring framework for access to information by competent national authorities, recalling Article 25 of Directive 680 of 2016, and aim to prevent possible misconduct or inappropriate access to information. Also, recital 53 emphasizes the importance of the protection of personal data in accordance with Union law and this directive, and specified that this guarantee must be observed in relation to all exchanges of information under this directive. In this recital 53 is emphasized the importance of respect of some principles related to the processing of personal data: lawfulness, fairness, transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity, and confidentiality and accountability. Article 9, the content that request addressed to a foreign counterpart must have is more detailed than in the previous legislation. The requesting officer must specify the reason for this request, identifying its relevance to the activity to be carried out. Naturally becomes aware that this is very important. In number 3 of Article 9, it is specified that where national authority becomes aware that it is in possession of information that may be necessary for a foreign counterpart, the exchange of information must also take place ex officio, without a specific request. This seems to be an important clarification in a logic of fruitful cooperation. Another important rule is that member states must ensure that information provided by their asset recovery office can be used as evidence before the courts of another member state. Also, in the logic of efficiency of the system, this is a very important rule. The exchange, Article 9, number 5, establishes that the exchange of information must take place through the network application called Siena. This is a system managed directly by Europol, but also, when necessary, on an exceptional basis, other secure channels for exchanging information pursuant to this article. One guideline of the work package 3 emphasizes, for example, the opportunity of increasing contacts with and between the so-called financial intelligence units of the member states or the networks of such financial intelligence units. And also what was a guidelines which was proposed by Spain, the need to avoid simultaneous transmission of European investigation order or other system for banking and financial information through parallel channels, because this has occasionally hindered rather than expedited the initiation of the process of execution by creating duplicities, overlapping, and internal confusion. The refusal, Article 9, number 6, regulates the refusal to provide the requested information that must be justified on the basis of some specific case, harm the fundamental national security interests of the member states, jeopardize an ongoing investigation of criminal intelligence operation, or pose an imminent threat to the life or physical integrity of a person, or be clearly disproportionate or irrelevant with regard to the purpose for which it has been requested. This last case was envisaged by the Council. A further case of refusal is introduced. The Parliament wanted to introduce a further the hypothesis that it might not be in accordance with the principle of national law, the Charter of Fundamental Rights, but it was not introduced, even if the respect of the procedural safeguards is included in any case in these rules. The refusal should be reasoned, motivated, and might be partial, only for a part of the requested information. Article 10 lays down the deadlines for responding to requests for information. without changing general deadlines, also with the farmer worker decision on 960 of 2006. In any case, in addition to the existing legislation, it distinguishes between non-urgent request to be fulfilled within 7 days and urgent request to be fulfilled within 8 hours, extendable by up to 3 days. The council wanted that the 7 days become 14 days, but it is for non-urgent request, but it was not included. In any case, this is for information to which they have direct access. This specification was included in the final version, to which this was wanted by the council and was included in the final version. For the 3 calendar days for urgent requests concerning information to which they don't have direct access. Okay, to end, I would like to stress that in Article 17 obliges member states to take the necessary measure to ensure the tracing and identification of assets also after a final criminal conviction or following proceeding pursuant to Article 15 and 16, confiscation without conviction. This should involve a subsequent investigation aimed at identifying the asset to be confiscated. It is not specified, but I suppose that also the role of asset recovery office can be important also in this phase. In this case, there are some problems. Article 15 is important for the effective confiscation and execution, but there is also included a reasonable time limit in the recital 36. It is established the possibility to introduce a reasonable time limits, because in this case there are also the problem to avoid that the threat of this of a freezing order, of a confiscation order, becomes a sword with Damocles indefinitely over the freedom of economic initiative. It is also the problem connected with the action in rem, and also the European Court of Human Rights has established in some case that this possibility of freezing and confiscate again and again without reasonable limit is against also the principle of legality and the foreseeability of the consequences of our action. Also in other case, and also to the case. Okay. In the end, recital 60 reiterates the importance of combining efficiency with safeguard in order to ensure that there is a common understanding and minimum standards for asset tracing and identification. This directive should lay down minimum rules for the relevant measure as well as related safeguards. And so this is in any case important for each member state to find this good balance, also in improving the role of asset recovery office. In my opinion, it would be important for the future to establish which are the reforms that each member state has to introduce in order to improve the role of asset recovery office, and also to find a good relationship and the efficiency in the relationship between the law enforcement agency and the judicial authorities in order to avoid loss of time or loss of work. Thank you so much.
Any question to Anna Maria Malgeri coming from the people connected? I don't see any hand action. Okay, I think we can proceed. Okay, we are having the different country profiles. As you can see from the agenda, I really don't know who is connected. I see the representative of the Italian Minister of Justice connected in front of me. I'm really happy he is here. And if there are no questions to Professor Malgeri, we can proceed with the country profile, which we lost with a break for lunch until this afternoon. Please, representative of the Italian Minister of Justice, welcome aboard. Check the microphone.
Here. Yeah. Good morning, everyone, first of all, and special greetings to Professor Savona, Anna Maria, and all the colleagues and friends who are taking part in the meeting today. Also, special thanks to Professor Savona and Anna Maria for doing all their efforts to keep this project going along, and for arranging also particularly this workshop. Just a second. Before starting, I would like to introduce to all of you, Anna Maria already knows her, my dear colleague Diana Russo, who we were able to take her on board of the project as well from the side of Ministry of Justice, and will take part along with me in the incoming activity connected to the project, to the recovery project. We, of course, as regards particularly the topics dealt with in this workshop, I guess Colonel Ribaldo already told you that this is a matter which is not directly handled by the Ministry of Justice, nor by judicial authorities, as the ARO activities, the ARO offices, the Italian ARO, is definitely part of the law enforcement system in Italy. Anyway, of course, we kind of keep control on their activities, and that's why we will be talking during our intervention from two different points of view. Diana will will read through some articles of the new directive, focusing on Article 5 and on the concerns which will be arisen, also with a specific, having specific in view the specific reservation made for the member states to provide for a preliminary authorization coming from a judicial authority. For myself, I will deal with something which happened before the directive went through, and with the issues we stumbled across before the directive went through, and maybe which have been addressed by the directive, and maybe also will be solved by the directive. When it comes to mutual legal assistance requests regarding asset tracing identification as a central authority, so also when adding our institutional meetings, but also way of dealing with the regulatory letters coming from our judicial authorities. We used to, before the directive went through, we used to give our judicial authority as a sort of best practice some instructions in order to draft proper mutual legal assistance requests concerning the tracing identification of assets. When we experienced it during our history of cooperation, central authority involved in international judicial cooperation, was that most of the rogatory letters were denied, the execution was denied or was anyway postponed due to the so-called phishing issue. Most of the requests coming from the judicial authority could be considered as overload fraud in order to identify the assets to be seized and confiscated. That's why we recommended our judicial authority to use all the possible informal channel of communication and of assistance, also informal, in order to take care of this preliminary part of the mutual legal assistance request, the identification of the assets. We told them, as I said, either in official replays before prior to send out the request, or also while during workshop giving them instruction on best practices to identify when it comes to bank or funding accounts, of course the number of the account, the name of the bank, the name of the intermediary, but